A lot of people who are in the US under Biden's humanitarian parole programs and TPS designations are now panicking because those programs might be coming to an end. I mean, some of them are definitely coming to an end. Some of them, it's yet to exactly be seen, depending on what happens in certain court battles. But now people are scrambling to figure out what's next. They were promised entry and a life in the United States. And even though TPS was never meant to be permanent, people relied on what they viewed as promises. And now they're here, they started a new life, and now they don't know what the future holds. And there's an analogy I would draw here where if you speak to a sick person or someone who has a severe illness, they would tell you that they used to have hundreds of hopes and dreams, but then after they got sick, they only have one hope and dream, and that's to get better. And I view immigration a lot like that. Like, it's hard to have hopes and dreams for the future when you don't have steady immigration status and it's not even clear whether you're going to be allowed to live in the United States in the future. So I deeply empathize with people who are in this situation. And I've been in the unfortunate situation of having to do lots of consultations with people where I just have to give them bad options for the future. So let's talk about what some of those might look like. And specifically, I've seen a lot of people wasting money on I-130 family petitions when they're not eligible to adjust status. So after I talk about some options people might want to consider very briefly, what I really want to talk about are the I-130 category petitions, the family petitions, where you might actually be able to benefit and become a permanent resident in the United States. Okay, so the two main options I always screen people for when their TPS and parole is coming to an end is, do they have a valid asylum claim? And much less likely, do they have a valid claim for a U visa? So I'll just start with the U visa because it's quicker. A U visa is for victims of crime in the United States. So if you've ever been harmed or the victim of a crime in the United States and you suffered either physical harm, physical injury or harm, or pretty severe psychological harm, and you called law enforcement or in some way cooperated with law enforcement, just calling them is usually enough, informing the police of the crime and then remaining available, even if they don't follow up with you, you might be eligible for a U visa, which is a pretty solid pathway to permanent residence. Now, the main problem with it is it can currently take like 5 to 7 years, and you're not really protected during that 5 to 7 year period. But if you have nothing else, I would definitely consider applying for a U visa if you're eligible. The other thing that a lot of people, especially from certain countries that are just like in a free fall right now, might be eligible for is asylum. I see a lot of people thinking that they qualify for asylum because their country's at war, or in the case of Haiti, pretty much in a civil war. But asylum's tricky because you need to connect your fear of persecution if you go back to your home country to one of the 5 bases for asylum. And those 5 reasons for asylum are race, religion, nationality, political opinion, or membership in a particular social group. And that last one, social group, an example of that would be, like, for example, if you're gay and there's a history of persecution for being gay in your home country, that would usually amount to a particular social group, but it's country specific, and there are other social groups in different countries, so it's really country and research specific to your country. One final note about asylum before I move on. You typically need to apply for asylum within 1 year of entering the US, but there's an exception. And the exception is if there are exceptional circumstances or changed country conditions, you must apply within a reasonable time. And something that qualifies as an exceptional circumstance is if you had some other immigration status or quasi-immigration status, such as parole or TPS. In that case, I would argue that once that status ends, you must apply within a reasonable time. That doesn't mean you have a full year. It depends on what the adjudicator or judge determines was reasonable under those circumstances. I advise most people try to apply within 1 to 2 months after your other status ends. I think in most situations that would be considered to be a reasonable time. Okay, but what if you have US citizen or permanent resident resident family members in the United States, can they just file a family petition for you and protect you while you're waiting for that visa to become available or for your green card to become available? The answer is maybe. And the answer depends on which category of family petition. So if you are filing a sibling petition, you're a US citizen who wants to file a petition for your sibling, you're probably wasting your money. If you're filing a petition for an adult son or daughter, regardless of whether you yourself are a US citizen or permanent resident, you're probably wasting your money if that adult son or daughter is currently in TPS or parole and that status is about to expire. If you're a permanent resident filing a petition for anybody, with some exceptions, it's probably a waste of money if that family member is in the US and they're going to be unlawfully present at any point during this process. And the reason is because these are considered preference category petitions. For a preference category petition, you have to wait for the visa to become available before you can apply for adjustment of status. And if that visa becomes available, in the case of siblings, that can take more than 15 years for the visa to become available. If it becomes available 15 years from now, at that point, your sibling won't really be able to apply for adjustment of status because they'll be out of status. And when you're out of status, you can't fix your status through a preference category petition unless you leave the US and do it through a consulate abroad. If that's the plan, that might work. You'll probably need an unlawful presence waiver depending on the situation. You might not qualify for the unlawful presence waiver if you don't have a spouse or a parent who's a permanent resident or a US citizen. So just some things to keep in mind. If this is getting really confusing for you, you guys can always schedule a consultation directly with me. My information is in the video description below, and I'll go through your exact facts of your case to explain exactly what your specific options are. There are a couple categories of petition that would be a remedy in this example. So the example is your TPS or humanitarian parole or both are about to expire or recently expired, and you want to adjust status through a family petition. So the three categories of petition that can do this, even if you fall out of status, are marriage to a US citizen, as long as you entered legally. Actually, for all these, as long as you entered legally. The other one would be petitioning for a child of a US citizen if that child is under 21 and unmarried. And then the last one is a US citizen who's 21 or older can petition for a parent who's here, even if they're out of status, as long as they entered legally with a visa or were paroled into the United States. Any other category of petition other than these three categories, which are referred to as immediate relative petitions. So any other category would be considered a preference category petition. If you're an immediate relative petition, you can adjust status even if you're out of status. If you're in a preference category petition, it's much harder. You have to wait for the visa to become available. You have to be in a valid non-immigrant status when that visa becomes available if you want to adjust status in the US. Otherwise, you'll need to leave the US to do a consulate interview abroad, and that's complicated. If you have more than a year of unlawful presence in the US, you'll need an unlawful presence waiver before you go abroad. That'll take another 4 years. It's complicated. You might not qualify. Speak to an attorney if that's your particular situation. Anyway, guys, I've seen a lot of people recently from certain countries like Haiti, Venezuela, Ukraine, filing petitions for siblings and filing petitions for adult sons or daughters or people who are married. And I have to break the news to them that they will probably never be able to benefit from that petition if their plan is to just remain in the US continuously. And even if they can benefit from it, they'll probably need to leave the US at some point, and they might need an unlawful presence waiver before they leave the US. And when I explain that to a lot of people, they tell me, oh, if I knew that, I wouldn't have wasted the $625 application fee filing these. We wish we had spoken to you sooner. So don't let that be you. If you want to speak to me sooner, you could schedule a consultation. My information is in the video description below. You could also go to my website to find the consultation link. If you're new to my channel, I try to put out videos on a weekly basis on family-based immigration, naturalization, and changes to immigration policy under the Trump administration. If you want to learn more about these things, be sure to subscribe, and I'll see you guys next time for another video.